just want to thank everybody for coming here today and chatting with myself and Charles. Very fortunate to have Charles here. He is an attorney that we do a lot of work with. He handles everything from trademark law, franchise law, really working with small businesses to make sure that their brand is protected. And he's our go-to guy. So when we have any issues, or even when we don't have issues and we need to protect the brands that we create, we reach out to Charles and he handles it. So before this webinar took place, we thought it would be really helpful if I could share with Charles, a lot of what the typical questions we get from people are, like there's so many questions about trademarking and trademark law and how to protect your intellectual property, whether you're a designer, whether you're a business owner. And these are things that, I wish I didn't have to deal with quite as much as I do from people who infringe on a lot of our clients' intellectual property. But it's really good to share this information so people know kind of what's important, what they need to do to stay out of trouble, and how to really protect their assets. So we've worked with Charles and his law firm for, I don't know, probably about 5 or 6 years. Charles and I actually went to high school together. Everyone in the high school apparently had no hair, so that's part of what we seems like we just went to our 30th class reunion, and it seemed to be a common theme. So in any event, I wanted to just thank Charles for joining us today and really sharing some knowledge and helping to put together this webinar. The law firm that he works at is called INTERNICOLA Law Firm. It's based out of Staten Island currently, and then they're moving to Red Bank, New Jersey, but they deal with clients all over the globe and all over the country, obviously. So we're going to run through some of the questions that we had prepared ahead of time, and then afterwards, or even during some of the webinar, if you have a specific question that you want to try to have Charles address or answer for you, just use that group chat feature, and then we can have Charles chime in on that. And then, if you want to wait to the end, we're going to have some Q&A at the end as well. So certainly we could do it at that point. So first, Mark, so one of the big questions we always get is, what are the differences between copyright and trademark? So copyrights and trademarks are two different forms of intellectual property and protection. And I'm going to let Charles talk a little bit about this next slide, which details out the differences.
That's great. Hey, thanks, Dan. This should be productive. And so we see often, especially when there's a new brand or a brand that has a new logo, there's definitely confusion about a trademark versus a copyright. If for the people that are on the call right now, if you're a business owner, if you're concerned about protecting your brand, your business name, your logo, things like that, then I want you to think about one thing, which is you need trademark protection. So the difference is a copyright is, when you hear about a copyright, think about a book, literature, movies, anything where there's a work of authorship, and that authorship is fixed in some type of medium, whether it's a book, a movie, a video, an app. So for the vast majority of brands, whether it's home service-based businesses, you're really going to want to focus on your trademark. So copyright is a work of authorship, like a TV, movie, or a book. A trademark is what identifies your business, right? How do people identify your business? And the most common examples are your business name, your logo, and potentially your slogan. So technically, a trademark is what identifies your business, what identifies the goods you sell or the services you provide.
Okay. So we have, the next question, I'm sure some people think, well, isn't everything that's created inherently already copyrighted? So why do I need to take another step? Like, why is that so important to really understand the differences between the two? And if something I create is already copyrighted, then what's the difference? Like, why do I want to go through that extra step of actually protecting that information?
Okay, so I'm going to skip to the end for 1 second. And the most important thing that everyone listening to this needs to know, that you need to protect your business name, your logo, your slogan. The way you're going to protect it is through your trademark protection, okay? And the best way to protect your trademark is through registration with the United States Patent and Trademark Office. But let's deal with both of these, copyright, trademark. Let's assume for a moment we're interested in copyright protection. There's copy for a website. There's a book that was written, say, top 10 ways to save money when you hire an HVAC expert, things like that, a work of authorship. That would be something you'd want to protect in terms of copyright. Now, when that authorship is complete, it's put in a medium, we publish top 10 ways to save money with your HVAC vendor. At that moment, there's inherent copyright protection applies. However, if a competitor steals that work and we want to sue them, the way we could to sue them, we need to first have our copyright registered, right? And that's with the U.S. Copyright Office. So for most businesses, most service-based businesses, you're not going to be completely focused on your copyright protection, but if you have a great publication that you think could be knocked off, then you file that with the U.S. Copyright Office. If someone does knock it off, then you could sue them and you have enhanced rights against that party. So that's why you want to file for copyright registration, even though you have a form of protection.
Okay.
Let's get into the trademark element, because that's where we get all of the questions, Dan, and so many of your brands, which are, so let's assume we have a really smart business owner. He's in a service-based business, or she's in a service-based business. You guys just launched a great logo. The logo looks amazing, and they have a great name, right? And the name is great, not because it sounds so great, but because people know it in the marketplace, and it has value. People recognize it. On the day their new logo's ready, on the first day they started using their business name, under the law, they get automatic trademark rights, meaning it's what we call legally a common law trademark. What do you do to get a common law trademark? You do nothing other than, I started my business, I'm using my business name. Let's assume the business name is not descriptive. And so on day one, I'm in San Diego, and I have my HVAC business as an example. I use my business name. On that day, I start obtaining common law trademark protection, okay? You redo my logo, we start using it. When I start using that new logo, on that day, I get automatic common law trademark protection. So what is common law trademark protection? Well, I'm using the mark in San Diego. If someone the next day adopts a name that's similar to mine or confusingly similar, or they knock off my logo and they're in my same market, San Diego, or a market that's close where I would naturally expand, I could, in theory, sue them in court and claim that I have trademark protection, and it would be a common law trademark, and have an effective case, right? Now, if someone in another state or outside of my area of service starts adopting that mark, my common law protection is not going to extend to it.
Okay.
So when you file for trademark registration, what happens is you're filing with the federal government. You're saying, hey, here's my new logo. We file it with the United States Patent and Trademark Office, which we keep referring to as the USPTO. We go through a process of registration. Once it's registered on that day,
oh yeah, I'm okay.
Effectively, the entire country is frozen, and no one can adopt our mark or confusingly similar mark after the date of our registration, okay? And unlike a common law mark, so our protection's national, and also when we have registration, we're entitled to other protections when we sue someone who's infringing on the marks.
Right.
So both copyrights and trademarks automatically protected when you first create them or use them. But your real protection against third parties, and especially if you're going to expand or franchise, you want to file for a federal registration of those items.
And you know what? That's so, like, what's so important about what you just said is when you're talking about the common law being mainly dealing with locality, right? So someone in my own community takes the name, takes the logo, or takes, you know, the tagline, whatever the case may be. But most of the instances that we see of brands being stolen, they're not being stolen within the communities that they're in. They're being stolen across state lines in different areas. So again, the common law in theory is like, well, I don't really care if, you know, no one in my community is going to take it. Well, that's fine on one hand, but if you're trying to build something that's a larger brand, or maybe it's a larger brand down the road, if it happens in another state, then you've got no protection without the trademark.
Yeah, I mean, Dan, it's right on target. Look, if you're serious about your business, building your business, if you are serious enough to hire your company and your team to develop a logo, there's no excuse not to register your trademark.
Yeah.
And it's a sellable asset, even if you stay local. Or we see a ton of brands come to us, and they're ready to franchise. Great brand, great logo, but you have third-party usage all over the country, and that becomes very difficult because then they can't sell licenses in those states.
Right. Okay. All right, cool. So I just had this awesome new logo created by, you know, a design agency or a sign shop or whoever, and I want to do something now. I want to get this logo protected. So let's talk about the steps you need to take once you have this new brand created, and what do you need to do?
So I'm going to go back a second just for everyone. Everyone will see, actually in this slide, you'll see the R in a circle symbol. Everyone's probably familiar with that. You'll also see the TM symbol on there. Correct. So right now, whenever you're using your trade name, your business name, your logo, if you don't have USPTO registration, you should be using the TM symbol after your mark, your name and your logo.
Right.
That's an identifier. Legally, it's important because it's trying to create notice, even at the common law level, that, hey, I claim protection to this.
Right.
The R symbol symbolizes, hey, I've registered the mark with the government.
Right. So when we finish a logo project here, and we're preparing the final logo files, we automatically put the TM into that logo and the logo files. So right off the bat, like you said, it's already serving notice that is, even common law right there is you know, telling someone else that may think about stealing it, at least they see that symbol, and maybe that'll also cause them to have a second thought about, maybe I shouldn't steal this. Yeah,
and that's an important thing that you're doing. So what do you do after you have a new logo? First step is follow the advice that you guys are following, which is put that TM symbol on there, right? Okay. Second, in terms of a logo, now logos in many ways are simpler to register than a trade name, because with trade names, business names, it's very possible that someone else has a very similar name already registered. If you're working with a real design company, right, like Original Designs, it should be a very straightforward process to register your logo, right?
Right.
So again, if, you know, you're creating the business, you're growing it, you're worried about customer service, you're focusing on your follow-up sequences, your systems, you need to protect the mark. So the second thing you need to do after you put the TM symbol, work with an attorney that's experienced in this area. Ask them to take a look at the trademark. They'll conduct a basic initial search. Have your trademark registration application prepared. Have it filed with the USPTO. And in 6 to 12 months, have it registered, right? So the second step is really to file a trademark application with the United States Patent and Trademark Office. Do it the right way, have the right classifications. So the second thing is to file for that registration. Right. Yeah. And I think it's important you note, as far as trying to work with a law firm that is experienced in this realm. And I think, you know, I tried to do it myself. I tried to, you know, get my first trademark done myself. And it was, I didn't know what I was doing. And it cost me time, and it cost me a lot of additional hours of my own time just trying to figure it all out. And then the first time I submitted it, it got rejected because I didn't prepare it properly. So like,
I thought I kind of could do it myself. And I said, well, this doesn't seem like it should be that complicated, but there's so much more involved. And even knowing and figuring out the class that you're trying to claim your trademark for, and making sure you're covering actually the right lines of business and things like that. So I think it's a wise investment to make by hiring a law firm that's experienced in this realm. And not all lawyers, I think, really are, knowledgeable. I mean, I'm sure that any lawyer maybe could do it, but I'm not sure if you're not doing this all the time that you know the ins and outs on how to get something through and how to maybe counter if an examiner at the USTPO comes back to you and says, well, we want to reject this because of this. So having someone that can defend your application process, I think, is really critical too.
Yeah, look, business owners need to balance between two extremes. Do it yourself on an online portal to a law firm that is really not for them, is going to charge a lot of money to file a trademark, right? On the do-it-yourself portals, a couple of things we see often. One, the trademark's not registered properly, and then years later, when we're looking at expansion or an acquisition, the protection they thought they had is nominal. Second thing we see is, like you mentioned, they'll get an initial response from the examining attorney, not know how to respond to it or not respond to it, and then they abandon their application, right? On the other end of the spectrum, you have law firms that treat you as if you're Coca-Cola and Pepsi, and you're incurring fees that you really don't need to. Look, you're going to have filing fees with the government. It depends on how many classifications and service areas. But as a general rule, if you're working with someone who's focused on brands and trademarks, and this is part of their DNA and what they do, your filing should be under $1,500, including disbursements.
Okay.
So, and I'll say this, I mean, to me, we protect our intellectual property. We do a bunch of things, but especially in these service-based industries, especially where you're investing in these logos and this brand identification and building websites and collateral around it, it's inexcusable not to get this protection. I mean, it really is.
Yeah, and certainly, you've seen a number of examples of brands that we've created that have been ripped off, and then when we go to try to take action on that, some of our options are limited because the client hasn't actually registered yet for the federal trademark. So then they take the step to try to do it at that point, where from a defensive standpoint, it's not really the best position to be in just yet. So it puts them at a distinct disadvantage should someone actually steal it in the meantime.
Yeah, and Dan, something I saw with your team, and we do often, so there'll be times where you'll even contact me and, you're working on a design or a brand name, and you'll reach out to me and say, hey, do you see any potential issues? So what happens often too is, when you file a trademark application, it may take 6 months to hear back from the government. And that's a long period of time. And sometimes government may come back and say, this mark, your name, is not even capable of protection. Because, right, for example, it's a generic description of the market, like, quick HVAC repair, right? Or speedy. So the government may come back and say it's a generic description and we don't grant protection to generic. Well, I know you've come to us often to ask our advice on things. Well, before you file, that's the time to evaluate, is it capable of protection?
Right.
If not, maybe some modifications are needed. And then we don't get a rejection notice, rather we start getting registration. And before they invest in collateral materials and other things.
Yeah. And we often, we come to you a lot, even as we're in the planning stages of a new brand, when we're doing naming for clients, and we'll do a preliminary search ourselves and search and see if this particular name is available. But often, you've helped us out a lot just by saying, dude, you're not going to get this through. So we know, we don't even bother trying to pitch a name like this because it's just never going to be able to be protectable. So that's really, I think, some really good insights there too as well. So, all right, cool. So next one. So Should I trademark my name, my logo, or both? And how about my tagline? So I just want to actually talk really quick for a second about this when we came up with the name for KickCharge and we sought protection for the KickCharge name. So we did two things. We actually did three things. We protected the name KickCharge, we protected the mark for KickCharge, and then we protected the tagline for KickCharge. But I want people to understand that when you seek protection, that you're protecting it for a certain line of business. So right now within the United States, there can't be another KickCharge creative that is engaged in advertising and marketing and digital marketing and branding. So we have that. Basically, there isn't anyone else that can use that. However, like we learned like about a year ago that there was another company called KickCharge, and they actually manufacture batteries that charge phones. And there's nothing I can do about it. Like I called up Charles when I saw it. I'm like, dude, what's going on? Like, can we do anything here? And he's like, well, no, because like you're not a battery manufacturer. So I want people to also, make sure they understand that part of it too. But maybe you could talk about, names and then the mark itself. And then should we even bother with a tagline? Like is getting that tagline trademarked even worth it? Or, what are your thoughts on that?
So quick answer to all of this is trademark your name and logo. Tagline, that will merit a conversation depending on whether or not your tagline's descriptive. So this is an important distinction. So let's use KickCharge. Let's assume we register the KickCharge logo and it's the K with the name KickCharge Creative next to it. And that's a logo registration. Mm-hmm. Your name's a dominant feature of that logo, okay? So for sure you want to register that logo. Does it create some crossover protection for your name itself? It does, as part of your logo. But certainly you want to file and register your name also, KickCharge, in its unstylized format, because there's so many applications of that without the logo itself. In most service-based businesses and a lot of businesses, KickCharge is a very distinctive brand. Whereas in certain service-based businesses, you have family names or you have unique names that aren't by themselves so unique, but they are in those communities, right? Mm-hmm. So it's important to just register the name by itself for that particular area.
Okay.
And it's also important to register the logo separately, right? Now on the tagline, if you can register it, you should. Many times when clients come to us about their taglines, we don't recommend it because a lot of times their taglines are very descriptive, okay? And so I love taglines, but a lot of times they're not working with, a lot of taglines are very generic.
Right.
So if it's something part of the brand and unique and it's not descriptive, certainly you should register the tagline. I would, in order of, I can't even say order of priority, logo and trade name together, each of them,
right? You
need to do both. Tagline, it's just going to depend on what the tagline is.
Yeah. And we got, I think when you handled ours, we did the K also just by itself. The K from KickCharge is actually
correct.
There's the K on my shirt there. Because we wanted to make sure again that no one was going to ever be able to just use that by itself. And then our tagline as powerful marketing solutions, we got that registered as well. So yeah, I think sometimes you're right. You see something very generic for a tagline, like, amazing service since 1939. And it's like, well, that's too broad of a, you can't own that as a specific tagline, something like that.
Right.
Yeah. Okay.
Yeah, and look, the example you just raised with KickCharge. So by registering the K and the lightning bolt together just by themselves without the name, we actually expanded your protection because now another creative agency, say they don't use the name KickCharge, but they have lightning bolts or say it's another business that has a K in its name, mm-hmm. and they come up with a design similar to that, we now have an argument there
right.
that we wouldn't have if you just filed the name itself.
Yeah. Okay. So how long does the process usually take to file a trademark, Charles?
9 to 12 months. It depends on how the examining attorney responds. So what will happen is we'll file the application. It takes about 4 to 6 months for the government to assign an examining attorney.
Okay.
The examining attorney will then review the application and send out what they call an office action letter, which will identify potential objections to registration. Common ones are, it's descriptive, or, hey, we found a conflicting mark, and there's other items. Many times it just takes a mild amendment, right? So for example, if it's kick charge creative, the examining attorney may come back and say, okay, just disclaim the right to exclusively use creative. So basically we're saying the main component of the mark is kick charge, and we're not saying no one can file creative. Then there's situations where they may find a competing mark. In that case, then we work with our clients. There's ways to overcome the examining attorney's objection. So I'd say it's about 50-50. And depending on how we evaluate it, that's when we decide whether with the client they should rebrand or it's worth the effort to keep pursuing it.
Gotcha.
Many times it's worth the effort.
Okay. All right. So my favorite topic. So what do I do if someone steals my logo? What are the first steps? What should you do? What should you not do? You know, talk a little bit about that.
Okay. So let's just divide this up into two items. In item one, let's assume you never filed for your trademark protection for USPTO registration. So all we're relying on is our common law mark. And in the second spectrum, let's assume we have trademark registration with the United States Patent and Trademark Office. If it's a local competitor who's knocking you off, using a name that's confusingly similar, logo confusingly similar, well, in that instance, there's a very, very high incentive to say you need to send them a cease and desist notice where you advise them, hey, we have use of this mark. We've been using it prior to your usage. And therefore, we want you to stop using it, right? In that case, you should absolutely send a cease and desist notice. If they don't respond, you should be working with your attorney to pursue them. Otherwise, you're going to have confusion in the marketplace. Now, if the person that's knocking off your brand is not in your market, let's say is in another state, you're going to have a problem because your protection under common law is very limited geographically, okay? Second example, let's assume you have USPTO trademark registration. Naturally, in the local market, you'll do the same thing. By having USPTO registration, you're going to have enhanced rights if you do sue them. You may be entitled to more damages, treble damages. But now let's go in the scenario where the knockoff is in another state. Well, you definitely need to work with your attorney. The first thing your attorney should be doing is, okay, let's take a look at this other company. Because what we want to make sure is they started using the mark after your registration, okay? So things like your attorney should be looking at when they registered their website domain and other indicators of, hey, do they start operating before you or after? I would then send out a cease and desist notice. Sometimes if the company was using their mark before your registration, they can continue to use it in that local market. They can't expand their use. They may say, hey, we've been using it prior to you. If they weren't, they have to stop using the mark.
Okay.
And in that case, which gets to, and and it's something we discuss a lot. I know you bring up a lot, Dan. You know, the whole balancing act is this. What you never want to do is send a cease and desist notice and not follow up on it. So if you send out a notice to this company out of state, they don't respond, which is very common because people want to ignore this stuff, or they're just busy running their business and they hope it goes away, and you do nothing. Well, what you're doing is you're creating a record of not enforcing the protection of your mark. Even if your mark is registered, you're destabilizing it. And ultimately, it's going to be problematic. Now, when I say ultimately, hey, is your business growing? Are you expanding locally? Are you expanding nationally? This all plays in. If your goal is to expand nationally, you have to send a cease and desist. You have to pursue it, even if it means a lawsuit. And of course, in that process, your attorney should and will be practical of, hey, it's sort of a knockoff, but it's not close enough, or, it's all going to depend. Are consumers confused? Do you have emails from people saying they're confused? Or your attorney may be working with you to focus on that and getting evidence of that confusion.
Okay. All right. So, of course, I have many examples, and we could just run through some of them quickly. But, again, the benchmark that we talk about is related to whether or not the brands are confusing in the marketplace or likely to be confused. So, a couple examples here. This is the original brand that we created, and then this is obviously one that was a knockoff. Not only did they steal the kind of the concept of it, but then they also kind of used the name. And like we as one example, and then another one where obviously the exact same mascot was deployed here for this company, and our client Hansen pursued this and got this other company to stop using that. And that was a company too that had it in multiple places. They had it on truck wraps, they had it on websites, they had it on uniforms, and all those things needed to be basically done over. So kind of just speaks to part of the rationale as to why you want to make sure that you're hiring a reputable company to handle the branding. In some of these instances, the company that was infringing on another company had actually no idea that their artwork was stolen from somewhere else, because they got sold it and they assumed that whoever they bought it from was doing the right thing, and then they find out later that their artwork was sold to them, and actually they didn't even have the rights to sell it to them because they just took it from somewhere else. A couple examples. I want to talk a little bit too, even about designs as they integrate on vehicles, and whether or not those elements are somewhat protectable. So an example here is this client down here that we created the artwork for, Air Experts, and then these are two other companies that use that same exact artwork. So does the trademark then still carry through on truck wraps and design of truck wraps? Can you actually really claim ownership of the way in which that brand is integrated on a vehicle and say that that's your IP?
Actually, Dan, could we go back 2 slides? Just the example you gave is really good, and I'll go back to that. Let's look at the Francis and the Hansen, and let's go back to the question, which was a smart one that you had, which is, do I register the logo or the name and so forth, right? So in this case, Francis Hansen, technically the trade name is very different, right?
Right.
So in this case, if we had just registered Hansen Heating and Air, right? Our USPTO trademark protection would only apply to that, right?
Right.
So in this case, a good example. Now, in this case, the Hansen logo altogether, that's really important that this logo was registered as a complete logo with the name itself, right? So I think that's an important point as to why you want the logo protected. You also want your name separately protected, because let's assume someone didn't knock off your design, but Hansen's big in that community, or it has a different meaning, you're going to want that separately registered. So I think those slides show a good example of why you want both registered.
Okay.
And just for everyone who's looking, because this comes up often, people think that sometimes, okay, it's Hansen Heating and Air, but I'm Hansen Pros, and so it's a little different. When we talk about trademark infringement, it's the dominant feature of the mark, right? So in this case, Hansen is the dominant feature. Adding the word pro after it or adding another identifier isn't going to make it less infringing. And just so everyone knows, heating and air, naturally, that's descriptive. So that's, so if we filed with the government, they'd say, you don't claim that right. It's just to Hansen the word and to the design itself. So I think that's a good example of that.
Okay.
Let's shoot back to the truck wraps, because, right, this is a good example. So the answer is truck wraps per se are not protected if you look at it as just a truck wrap. But here, what I'm looking at, so let's assume I'm looking at Air Experts here, right? What I'm looking at is the logo. I mean, the fact that you stylized it and developed it in a certain way, this logo becomes part of that trade dress, colors, trade name and everything else. So if I'm looking at these examples here of these truck wraps, I think it's an easy argument that we're dealing with trademark infringement because our logo is protected, and these are confusingly similar usage of our logo. The fact that there's like slight modifications wouldn't.
It's not even really that slight.
No. No.
It's this one's, you know, I thought was, you know, again, pretty blatant, and using that standard, you know, as far as confusingly similar, I mean, you couldn't have these three companies in the same market. You know, that wouldn't work. So, I mean, because they're not in the same market doesn't mean that it still isn't trademark infringement. It would be that common law infringement if they were in the same market.
Correct.
Yeah.
Okay. Absolutely correct.
Okay. You know, this is another one too, where, you know, the same exact design here was duplicated as well. And then they just changed the name. So is that kind of cool? Like, can we just change the name and use the same exact structure of the other person's mark? And that doesn't fly?
No,
right?
In my opinion, again, infringement, and another reason why you want name and logo trademarks, right? Because, you know, in this case, the analysis would be it's confusingly similar. And having that the registration is very important, because someone will argue, well, it shouldn't be protected because it's a basic design, or it's not a basic design, or usage. Keep in mind, too, a tremendous benefit of obtaining registration with the United States Patent and Trademark Offices is after your 5th year of registration, as long as you file with the government that you're continuing to use the mark, you're granted what's called incontestability status, meaning if you sue someone, a lot of the defenses the other company could and would raise, a lot of them are waived or the burden is put on them. So there's a presumption after 5 years of registration that your mark is distinctive and that consumers recognize it and it has secondary meaning. So again, not stuff that business owners want to think about now and really ever want to think about these legal issues, but just know, after you get that registration, as that clock ticks, as you build your business, your protections get enhanced.
Gotcha. Okay. Yeah, and then this other example here, just again, the mascot itself, right? So, you know, they took elements of our original mascot design here. They simply duplicated it, kept the same colors. You know, what about that too? Like sometimes you see just the colors of the logo, like they want to change it a little bit. And people say, oh, well, if I change it, I always hear this weird percentage, like as long as it's 5% change, then I'm okay. You know, like, what's up with that? Like that doesn't fly either, right?
No, if we're talking about the same exact logo, different colors, I don't care what color it is.
Yeah. Okay. So this one here, again, more so speaking to the fact that the way the brand is integrated on this particular vehicle. This is a client of ours in San Diego, and then this was another company that we found out about that's actually in Pennsylvania that used the same design. And Mozzie sent them a cease and desist, and then they had to basically send proof that the design was stripped off their vehicles. They actually had, I think, 4 vehicles that needed to be done over from scratch. So, you know, it gets expensive, you know, to go through, you know, to not do it the right way, to use someone else's intellectual property, and then to think that you're not going to get caught. Like is the other thing that boggles my mind is that, you know, so in this particular instance, a sign company sold him the design and he didn't know that it was from someone else. So, you know, we see that sometimes often where, you know, again, the owner of the business doesn't even realize that what they purchased belongs to someone else. So this is a very expensive lesson, you know, essentially that they learned here. You know, again, another example here, you know, of our original client up here and then the design that we did, and then down here, obviously a very similar derivative, you know, and if these 2 vans were in the same market, I mean, they would just, you know, people would be confused, you know, they would look like the same thing.
Yeah, and if it's registered even in different markets, absolutely.
Yeah.
Together, they're all confusing.
Yeah, and this one here, again, different colors now, like we talked about. They changed the colors here, but they use the same exact mascot. And, you know, that didn't fly. And then this is one of my favorite ones. This is a twofer. So they stole the mascot from one, and then they stole the wrap design from another, and then they combined them together. So that was kind of a unique experience to have two taken from one original logo. So they used the colors from this one, and then the brand from that one. So
at least they're honest guys.
Yeah, right. That's irony, right? Let's call ourselves honest. In that particular instance, and let's talk about liability just for 1 second, though. So in some of these instances, we see that the artwork is provided to the sign company to reproduce. And are they liable for reproducing artwork that then belongs to someone else? So do they have any danger from reproducing artwork that belongs to someone else?
So, I mean, most print shops and companies, as part of their contract, will include a representation by the customer, where if you supply artwork, you represent that you have the right to use it, and so forth.
Okay.
So usually there's no intent on the production company. There's usually no liability. They're not, distributing it. I mean, if they're the ones producing this art, then of course there could be. But the answer to that is generally no. I mean, and if you're a print shop, and you should be covering yourself in terms of your contracts and what the representations are.
So, okay, so just make
sure.
sure.
Liabilities so I'm an HVAC guy, and I hire this company or crowdsourcing company. I get this logo design. I wrap all my trucks. I'm up, to 40 trucks. I have I could be exposed very seriously if someone has a registered trademark and significant legal issues. And look, once you get big enough, if the violation is clear, and we're not even talking about, usually the issues are, is there a likelihood of confusion? Are these similar or not? In these crowdsourcing situations, you're talking about straight knockoffs. So there's not even a dispute or an issue as to whether or not there is a likelihood of confusion. In those cases, you just may be a sitting duck, and you're going to have legal fees and a side that may not want to settle and may want to really pursue you.
Yeah. This is one that I know you handled and sent out cease and desist, and all these companies that had been using the marks. And you can see that they're not exact copies, but they're clearly derivatives. They're clearly inspired by and look very similar in nature. And in these instances, the companies, once notified of it, had to change all their trucks, their uniforms. There's another instance that's not from these companies, but there was another one where Timo's exact logo was then wrapped on 4 or 5 trucks, brand new trucks, and uniforms, the whole 9 yards. And the cost to them on that was, it's like almost $25,000 to redo all that stuff. So, making sure that whoever the business owner is working with is delivering something that's original, that's not based on someone else's intellectual property. It's, it seems really obvious, but it's something that's really, really important, because like you said, the sitting duck, basically, someone's going to know that belongs to someone else. I think I'm fortunate in the sense that a lot of people know of our work, and as soon as someone sees something out there that looks like one of our ripoffs, we get notified. So I'm very grateful for the design community for kind of keeping us apprised of what's happening. But it's just, it doesn't need to be that way if they just would hire a professional from the beginning. That's really the end. So again, does it matter if someone stole my logo but they're not in my area? Should I still pursue a claim? I think we talked a bit about that, but if you want to just retouch on that. The
answer is, as long as your mark is registered with the USPTO, you can. If it's not, it's going to be very difficult.
Okay. Are cease and desist typically effective? What about this thing about damages? Can I get damages? How does that work? Is that usually like a next level after the cease and desist, or potentially if the cease and desist are ignored?
So the cease and desist notice is one. If the mark is registered as part of the cease and desist, we notify them, hey, this is registered, registration number blank.
Yeah, yeah.
So they're more effective for registered trademarks, but they're, overall they're effective. The problem that happens with cease and desist notices is that many times the competitor may or may not be sophisticated or may not be getting good legal advice, and in that case they may ignore the cease and desist notice. And again, if it's ignored, you do have to pursue them to keep the protection of your mark. If your mark is registered, you're entitled to enhanced damages as you go through trial. In fact, treble damages, of 3 times the damages could be awarded if you have a federal registered mark and there's elements of intent. So you can pursue them. Many times, though, we'll pursue, and someone won't respond just out of sheer stupidity, or we'll get a crazy attorney on a call saying, no, we don't think it's infringement, and you're just shocked, and then eventually they settle. Mm-hmm. And in those cases, we look to recover attorney fees. In those cases, if our client hasn't been harmed, I'll usually advise them to settle because why incur more legal fees or have that risk? Why have the distraction? Also, when you do sue and the other side acquiesces or settles, that actually enhances your brand protection because now you have a track record of protecting your mark and other individuals acquiescing to that. So again, it's about building a sellable asset, maintaining that asset, protecting it. So they do work, but you have to be sincere about how you pursue infringers.
Charles, I had this client that had his brand stolen, and actually their name as well. And when he went after them, the guy was so ingrained in this brand as far as how much he had put it on all over the place. And he looked at the numbers and, he was just like, oh my God, like if I have to redo all this stuff, it's going to cost me a fortune. So what he wound up doing is leasing the use of that mark and that name. And my client granted him basically rights to use it in his particular territory. He was like, halfway across the country. So it wasn't near his community, and he didn't have plans to expand in that community, but he's basically wound up leasing the brand and the logo for, I think it was like $1,500 a month forever.
Right.
Because the guy's like, well, it's going to cost me $35,000 to redo all my trucks and everything I've put it on. So he decided to just basically lease its usage. I don't know what you think about that.
I think that's a great example, right? When we talk about sellable assets, building up assets, protecting it, if he didn't register the mark, or in that case, he had a valuable asset to be sold, in that case, a license. So I think that's a genius move. Also keep in mind, as other big companies or franchise companies enter, they may like your brand or a part of it. They may just go forward and with the viewpoint they'll overwhelm you with litigation and whatnot. Again, but not if you have USPTO trademark registration. And then in that case, maybe you're doing a license deal and getting paid to allow them to use it in certain markets.
Right. Okay. We talked a little bit about this, but do I have any recourse against a crowdsourcing site that sells me a logo which was stolen? I went to a crowdsourcing site and I entered this logo contest and I got all these different designs and I picked this one that I love. And then I put it all over everything I own. And then I got the cease and desist letter, and now I'm going to be out, tens of thousands of dollars to redo anything. What do I do now? What's my recourse? What can I do?
Look, I'm not an expert in this, but, it's buyer beware, right? When you sign up for crowdsourcing sites, they have a list of terms, and one of it is disclaiming liability and no representations as to the original work. And in theory, it's just a relationship between you and the designer, the so-called designer that you choose. So in my opinion, there's no recourse against them right now.
So
that may evolve and change over time. But from at least the crowdsourcing sites that I've seen, they're disclaiming that type of liability, and it looks pretty effective.
Yeah. So the designer is like from overseas somewhere.
Correct.
And, like, I'm not going to be able to like do anything about, like,
unless you go to Vietnam and go after the 8-year-old designer. Yes.
Okay. Okay. So yeah, here's a few examples of some of our work, either being misrepresented as work that they've done. So this is Fiverr. Like, if you were to go on Fiverr right now and type in truck wrap design, there's probably about 10 of our images being falsely advertised there as works on them. And it's just like very hard to keep up with the amount of times that they continue to, like, you squash one and another pops up. It's like whack-a-mole. It's really hard. But, you know, this is really my favorite one. I love to show this one. This dude here took our rocket drains logo, and he will awesome you a car truck wrap design. So, you know, I can't get to that level where I will awesome anything, and I'm
Right.
so hard, man. It's just like such a high benchmark. But, you know, this is continually to be something that you see. You know, you look here, there's 2 other ones that are ours, and this is another one that's ours. Another person that put all 4 of ours, you know, so it's just really hard because the stuff is just so prevalent. And again, people don't understand the risk that's involved in crowdsourcing and buying something from a crowdsourcing site. So a couple things we didn't talk to that I just want to bring up now real quick, Charles, is the idea of clip art and how clip art relates to trademarking or the potential to trademark. I'm a designer and I can't draw very well, so sometimes I use clip art from a stock photography site, and I integrate clip art in a logo. Now my client's got this logo with this clip art. What does that mean, and why is that maybe not such a good thing for that client to have a logo that's derived from clip art?
Yeah, look, like anything else, it's not genuine, but it becomes like a ticking time bomb. Say you go years with the mark, you think everything's great, you're growing, and then you pursue a competitor. And if a significant portion or a material portion of your mark is dependent on clip art from public domain, and if the defendant finds that out or knows that, you're going to have a hard time winning your case. So you may have the illusion of protection, but when it matters, you could be susceptible. So, I mean, look, there's just, you know, it's a fine line. You have to get to many levels where it's really going to matter. But if you're going to develop your brand and build around it, you really want to stay away from clip art.
Can I prevent then, let's say I have this logo and I've been using it for, you know, a number of years, but it is clip art, or it is based on clip art, and then another competitor that's local to me opens up a business and uses that same piece of art. Do I have any recourse, really, if it's public domain artwork?
There's some art. I mean, it gets to very deep levels of analysis in terms of litigation and trademark infringement. The answer is you could potentially have some claims just based on consumer confusion, common law usage, and this longevity, but I would not want to be relying on clip art. I mean, you could just get torpedoed at any time in litigation with that.
Okay. So let's just talk real quick about the idea of I have a design agency or I have a sign company and I'm asked to reproduce something that contains a logo or a character or something on a personal vehicle, let's just say, or something that's personal, that's not something that is meant to generate income, but we're selling this design work that uses, let's say, you know, Spider-Man for a kid's wall, or, you know, a bedroom wall that a client wants to wrap, or they have a personal car and they want to put some of these graphics on that utilize a Superman, let's just say. So why is that? Is that cool? Because it's not commercial. Like they're not trying to make a profit. The person you're selling it to is, what's the issues there?
Well, I mean, look, like if tomorrow I decided to sell Spider-Man T-shirts, naturally, I'm violating their intellectual property rights of, you know. in the case of Spider-Man, you know, and these famous trademarks, the production company, you know, the print company, it's a clear example where they know the party that's ordering this doesn't have a license to reproduce Spider-Man and produce wall art and things like that. So if there's a pattern of that, those companies could become susceptible to a claim, right? Think about it this way. Could that print shop put on their website, now selling Spider-Man wallpaper, right? No, that's an extreme example. They're affirmative. I don't think the fact that a customer orders Spider-Man wallpaper creates a shield, right? Now, will Marvel know? No, one-off, they won't. But does that make it right? No. And if there's a pattern, you know, it could evolve into something for sure.
What about, like, you know, I love Corvettes and I want to sell the Corvette logo or you know, integrate the Corvette logo into this really cool truck wrap design, and it's just the Corvette logo, but everything else around it is all my design. But it's kind of says Corvette there, but I did all this other cool stuff. Still doesn't fly?
Yeah, if you're using the Corvette logo, it doesn't fly, right? You don't have
not at all, right? So yeah, okay. All right, guys. I don't know if you guys have any other questions, but if you do, like, you can use the chat, the group chat feature if you guys want to ask anything specific for Charles that we didn't cover. Just, you know, type it in there. I know we covered a lot of bases here. This is going to be also recorded and then put on our website, and will be on YouTube as well. Hey, Chris. Okay, so Vin Ferreira asks, do law firms offer web monitoring services to track infringement?
So there's subscription services that third-party subscription services, and following the call, I could get you some of that information that we would hire to track that would track the trademark. So, for example, like Entrepreneur Magazine has a subscription service where even if files an entrepreneur trademark, they potentially look, they notify them and they send out notices. So law firms don't do it. We hire third-party monitoring companies, and I could get you some information on those. Okay. Chris, did you have a question? Chris Lee? Oh, okay. What about, Jimmy asks, what about using licensed materials from Shutterstock, Getty Images, and doing wraps? Are you covered license-wise? So when you download an image from Shutterstock or iStock Photo or Getty Images and you use that in your wrap design, that would fall under what they would consider to be acceptable use for them, correct? Yeah, and I think Shutterstock and those companies are pretty clear about when you purchase it, what type of license you're getting and the type of reproduction you could do. So yes. So Jimmy, yeah, I'm sure that that's part of what they would consider to be acceptable applications. I know the stock image sites like iStock specifically state in their terms that downloading vector-based images and then using them for logos are not permitted uses. So that's kind of a gray area the way it's worded, but it's basically saying that you can't sell it theoretically as a logo design and that your client can't claim ownership to that because that design is clip art essentially. So that's a little bit different, but certainly downloading photos and images and using them however you wish on a vehicle would be fine. So so let me go back to Chris. So Chris Lee wrote, just to verify, if you trademark after someone has started using your name, even though you were using it years before, the enforcement is not valid as they were using it before your trademark. So this is a situation where someone registers a mark after you've been using it? So it says if you trademark after someone has started using your name, correct, even though you were using it years before. That's a good question. The enforcement is not valid as they were using it before your trademark. Well, think of it this way. Say I'm in New York. Say, Dan, you're in San Diego. You're using the mark 20 years already. Kick charge. in San Diego. Let's assume you don't have a digital presence. I create Kick Charge Agency in New York today. I file for registration. I obtain registration. I will have protection. I can't come to you in San Diego, tell you to stop using it. I can't come to see it San Diego or that area. But you're going to have a problem that I registered the mark that you've been using all these years.
Gotcha. So again, like we talked about earlier, just important from day one, as soon as that mark is created, to get on that trademark right away and to get that going. So Sean asked, is there a place we can search to see if our logo or name is being used before building a brand? So where do they go to look for that, Charles?
So I think the first thing someone should do is go to the United States Patent and Trademark Office website, uspto.gov, and they have a trademark search feature, right? And in that trademark search feature, you could put in a name, and it'll produce results, and you can actually see the trademark filings. So I think that's a great first step to do a search of those marks. Logos are a little more difficult to search, but again, if you're talking about a uniquely designed logo like you guys do, Dan, that's usually not a problem. But the answer is go to uspto.gov, go do a trademark search, and you could get a pretty good evaluation of what's out there.
Yeah, and that's what we do when we do the naming of companies, and as we're ideating on different concepts, we may narrow down the list to a dozen, and then after we've narrowed down the list to a dozen that we like, then we hop on there and at least do that part of it first and see if that name is actually in use. And if it's in use, is it in use in our industry that we're representing? So we may see that there's a few trademarks with that name, but it's for totally different business sectors. So then we assume that we might have a better shot then at that point getting that name registered for our unique service that's different than what's already out there.
Yeah, and Dan and Cliff makes a good point. A regular Google search is effective too, right? That's really effective to pick up things.
Yeah. Weston, actually Weston did my embroidery. Big shout out to Weston. He's awesome. Weston from DGI Creative. Anyway, is it possible to protect processes or techniques in manufacturing production?
Yeah, so goes beyond my expertise. The answer is yes. But that goes into the realm of a patent. More
patent
based. Yeah, so there could be, for Weston, depending on his process and tech, there could be patent protection for that. And then a patent attorney would do some patent searches. And that's a very, patents are a more elaborate process to obtain than trademarks. But that would be in the realm of a patent.
Okay. Let's see, anybody else have any other questions? All right, I think that we're good then. Charles, listen, thanks so much for taking the time here, man. I mean, we covered so much ground, but I think it's so important. I can't wait to be able to share this webinar with people who are asking about it, because we get asked all the time, and people it's confusing sometimes for people to really understand. But I think we really covered a lot of ground here, and I appreciate you taking the time out to work with us. Charles, again, Charles's law firm, it's INTERNICOLA Law, and when we send out the link for everyone to, if they wanted to review this online, we will definitely include a link to Charles's contact info. Or if you guys ever need, help with trademarking, getting even franchising, Charles has really done amazing things for some of our clients that have gone on to actually franchise their business. So, Charles, dude, awesome. Thanks so much for hooking us up here, man.
Dan, ton of fun, man. Thank you.
All right. Thanks, guys.